I was about to come in and get Shark a super A++. He went in there in the beginning, and that man was batting 1,000. I'm like, dang. And the reason why he was going to get an A+ was because if you elicit emotions, you get that plus side. He could have got a regular A, and that would have been sufficient enough, but it was one of those, ooh, I get it moments. But, bruh, y'all know what we got to do. Let's run it.
DeMonte Kendrick petitioner, Chief Judge Earl Glanville, DeMonte Kendrick's emergency petition for writ of mandamus and stay of proceedings. Ooh, it's about to get crazy. We're not going to really read the table of contents like that. Basically, what they're about to say is the jurisdiction, explanation, relief side, issues presented, statement of facts, procedural history, the secret ex parte proceeding, the events in the court, Glanville's hearing on the motion recused order, argument citations, standards for granted writs of mandamus. Glanville has failed to show a bunch of times, and Chief Glanville's secret ex parte proceeding violated this code right here. Glanville's failing to follow USCR 25.3 violated at least Georgia Code of Judicial Conduct. And the conclusion. So, table of authorities. These are the cases in which they are reciting. Right here, we're really not going to get into it. So, here we go. Comes now DeMonte Kendrick petitioner, by and through his undersigned counsels, and brings this emergency petition for writs of mandamus and stay of proceedings showing as follows. Jurisdiction and explanation of emergency nature of petition. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to the conduct of Chief Judge Glanville and not any rulings or orders of the judge. This court has jurisdiction over this matter under GA Constitution 6.4 and OCGA 9.624. In the case at bar original relief, the form of motions for recusal have been filed and denied 3 times by 3 respective movants. Likewise, Glanville has denied the movants' respective requests for a certificate of immediate review 3 times. Glanville, as chief judge, has obstructed defense counsel's attempts to have a disinterested party, review the numerous allegations contained in at least 4 affidavits which allege judicial misconduct and unfair proceedings. These affidavits, if true, let me read that again for y'all. These affidavits, if true, which means they don't know if it's true or not, would constitute serious violations of the Code of Judicial Ethics, citing a lack of evidentiary foundation caused by Glanville's own recalcitrance in refusing to provide a transcript of a secret ex parte proceeding. Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review, assuming this court would not get the opportunity to review the decision on multiple motions to recuse unless or until the underlying case was concluded. Glanville continues to hide behind a purported standard that his actions would be reviewed in hindsight, meaning once we're done, they're going to come back and look for abuse of discretion. Glanville's obstruction of defendants' rights to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County would be ineffective. 3 motions for recusal have been filed and denied, and 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any effort to file a writ of mandamus in Fulton County that would be heard by Chief Judge Glanville, would result in frustration and lack of action. Glanville's court is where writs go to die. That's a hell of a thing to say. As the present petition for writ of mandamus will go to Glanville if filed in Fulton County Superior Court, petitioner has no option other than for the Georgia Supreme Court to exercise its discretion and consider defendants' claims. A secret ex parte proceeding was held on June 10, 2024, and attendants were Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from Fulton County DA's office, and members of the Fulton County Sheriff's Office. As a result of the proceeding on June 12, 2024, petitioner requested that the presiding judge, Glanville, recuse himself from petitioner's trial for, among other counts, count 2, murder, OCGA 16-5-1. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion recusal was summarily denied without following the required procedure of USCR 25.3, which means y'all went to a high court and the high court told y'all no. Glanville denied a request for a certificate of immediate review. A formal order denying the motion was entered on June 14, 2024, 2 days after the motion for recusal was filed. As chief judge of the Fulton County Superior Court, Glanville holds a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. Therefore, invoking the original jurisdiction of this court to issue writs is petitioner's only recourse. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in the case at bar will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Absent emergency release from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Anticipated areas of cross-examination includes Brady material that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as the coercive joint efforts of the bench and state. He just basically said the judge and the DA's office is dirty. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, casts a pall over any ruling that Glanville may make during counsel's cross-examination of Copeland. As Glanville has found petitioner's motion for recusal to have been filed and present in a timely fashion, the Weinstein affidavit, even though Weinstein didn't actually write it, Jay did, to be legally sufficient, and the affidavit containing facts that, if proven, would warrant recusal, petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign a motion for recusal for hearing before an unbiased judge. Petitioner further asks of this court that proceedings in the trial in 22 SC 1835-72 be stayed pending resolution of the motion for recusal. Petitioner further asks this court for a writ ordering Glanville to produce immediately and certainly no later than prior to the state of cross examination of Copeland and unredacted transcript of defendants of the secret ex parte proceeding held on June 12, 2024. Petitioner also asks of this court that it enter any further writs or orders it deems appropriate given the actions of Glanville. Issues presented. Whether Glanville was correct. Check that out. So if he was correct in failing to follow the mandates of USCR 25.3 by refusing to refer the motion for recusal to an unbiased judge for hearing following argument on June 12, 2024, particularly after making findings in an order on June 14, 2024, that the motion was timely, the attached affidavit was legally sufficient, and that the affidavit contains assertions of fact to support the allegations of bias and impartiality. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State versus DeMonte Kendrick. Jury selection took more than 10 months, with trial before the selected jury began in November 2023. Following the secret ex parte proceeding on June 10, 2024, petitioner filed and presented a motion to recuse and accompanying affidavit from Douglas Weinstein, Exhibit A to Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and the violations of the judicial code of conduct that occurred during that secret proceeding. The motion was summarily denied in its tenor, with a formal order issued on June 14, 2024. Exhibit B, the secret ex parte proceeding. A central figure, perhaps the central figure, in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. On Friday, June 7, 2024, Copeland was sworn in after being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify. Copeland continued to plead the fifth. See example A, Weinstein Affidavit 1. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10, 2024 at 8:30 a.m. where Copeland would announce whether he was prepared to testify. Unknown to any member of counsel, an ex parte proceeding was held in Glanville's chambers on June 10, 2024. Among the attendees were Glanville, ADA Love, ADA Hilton, investigators of Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of the Fifth Amendment rights being at a crucial phase of the trial. Neither Glanville nor any member of court staff nor Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding, either before, during, or after the proceeding. One or more members of defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor the DA's office. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. Upon information and belief, Copeland announced that he would invoke the Fifth Amendment right and not testify. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than testify. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Glanville working in concert with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at ex parte proceeding that he would testify. Upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and false statement statute of the state of Georgia during the ex parte proceeding. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Donovan Thomas. Important Brady material that has yet to be provided to Kendrick. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Caleb Bumpus, by through her counsel, filed a motion to quash, order to show cause, and motion to recuse attached Exhibit D on Friday, June 14, 2024, which subsequently supports the Weinstein affidavit as a partial in the ex parte proceeding. Bumpus' first-hand account of the misconduct is credible. The facts Attorney Bumpus asserts are as follows. On Monday, June 10, 2024, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Attorney Caleb Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify Exhibit D. Those present for the substantive portion of this ex parte proceeding were Glanville, Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court's security staff, and deputies, 2 investigators from the Fulton County District's office, and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to reassert his Fifth Amendment privilege. A conversation among parties ensued. A conversation. Understand, they said a conversation among the parties ensued regarding Copeland's understanding. So I'm talking to you to make sure you understand of immunity, how Copeland thought he may testify if he did not invoke the Fifth and certain facts of the case. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, who told him the 2 years. Copeland yielded. Copeland cautioned that his testimony would be a lie. And you see what happens? They didn't put the rest of that. That was held for a reason. Events in court about the time of the secret ex parte proceeding. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30. Admitted entrance into courtroom 1C, seated within 9 a.m. Exhibit A, Weinstein affidavit. Defense counsel waited between 11 a.m. and 11:30 a.m. Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. See, that ain't even what happened, though. You see how they just lied? We all watched that. Weinstein just lied, bruh. And this is why I tell y'all, the lawyers have a brotherhood, and I believe the judges have a brotherhood. But I'm going to put more into this in my explanation after this. But listen to what they just said. They said, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reasons for delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover a reason for the delay. That's a lie. That afternoon, when Steele's understanding of the morning events was presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, citing Rule 1.6 of the Rules of Professional Conduct, Glanville held Steele in criminal contempt and sentenced him to 20 days of incarceration. Glanville's hearing on the motion to recuse subsequent order on June 12, 2024. Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous ruling. Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10, 2024 secret ex parte proceeding was 1, in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including defendants such as Kendrick, a fair hearing, and 2, in violation of Rule 2.11a in the revised Georgia Code of Judicial Conduct that says generally that judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. During the June 12, 2024 hearing on the motion to recuse, Glanville refused to conduct the timely analysis required by USCR 25.3. Despite Weinstein bringing this to the court's attention, Glanville refused to make any findings and summarily denied the motion. Well, it's kind of crazy because in the beginning, you said that it's up to the courts. You said he may be right, but whatever. Weinstein requested that at the time a certificate of immediate review. That request was denied, foreclosing opportunity to appeal Glanville's ruling. Glanville stated that an appeals court could look at his denial at the conclusion of trial. On June 14, 2024, Glanville issued an order of motion to recuse. Chief Judge Glanville attached Exhibit B. The order primarily denied the motion. In that order, the court did make findings, though not in a timely fashion required by USCR 25.3. The court found all 3 prongs of Rule 25.3 satisfied, and the analysis should have been stopped there, Exhibit B, but Glanville did not. So, this is just going into the history. Them just saying that he's basically wrong. So, it's just really saying the same thing. Literally, it's all just saying the same dang thing I just read. So, we're just going to get into it. See right here, facts alleged Weinstein's affidavit must be assumed to be true when deciding whether recusal would be warranted. See USCR 25.3. The details learned by Weinstein upon information to believe detail the holding of improper ex parte hearing conducted with sworn witness Copeland. But let's just get into it. I'm going to keep scrolling down just to show y'all it's really no more to be said. So, here we go.
So, I caught the lawyer's line a couple of times. We seen what Brian Steele did. Brian Steele came down and basically asked about the ex parte meeting and turned around and essentially accused the judge of being dirty, and then basically got sentenced to 20 days in jail. The way they wrote it was, hey, all Brian Steele wanted to know was what was up with us taking so long. That's not what the hell happened at all. Zero. That's not what happened. Then on top of that, the lawyers just sat up there and said, based on facts and belief. What facts? What facts are y'all talking about? Y'all don't have any facts because y'all weren't there. Y'all keep on saying officers and all this stuff and everything like that, and y'all don't know. You don't. You're just going off of belief. It's not facts. The only facts you have is that there was an ex parte meeting and there was some officers in the court. And if it wasn't for Caleb Bumpus, I wouldn't have known it was two investigators in there. So y'all didn't even have that fact right. So it's stuff like that where you're going off of essentially secondhand information. I really believe Woody gave him that information. Woody gave the information to his lawyer, pissed off, and his lawyer basically sent that email pissed off. And basically it pissed off the whole entire defense team. That's what I believe. And within doing that, they just said, and this is where I will agree. I know what I said before, but I will agree with this. They said, you know what? Let's fire this off and see what the hell happens. That's what I truly believe. Because it's not looking like a big shot in the dark. But if they're able to pull this off, it's a shot in the dark. If they pull this off, case gets dropped, gets dismissed, mistrial, Thug coming home. So you have to do this. Bruh, we damn near got 2 more years of this anyways. So why the hell not? If there was a lawyer that had the balls to say it that way, I would promote that person for a year. Like, go check this person out, go check it. Bruh, I'm not in disagreement with what they're doing. I'm saying that the way the judge is walking around and acting and how he's doing what he's doing, I'm saying that judge probably don't believe he did anything wrong and probably didn't do anything wrong. That doesn't mean definitively he did wrong. I'm saying probably. That's all I'm saying is probably he did nothing wrong. I'm not saying he didn't do anything wrong. The same way that they said in belief of. And then y'all basically said, even if the judge was right, y'all still need to look at this. Just because they sent this up the road doesn't mean that the courts are going to hear it at all. So there's that. Y'all got to look at it this way. If y'all believe the courts to be as racist as y'all do, then who going to give a damn? Courts ain't finna care. You already got struck down by one court already. That didn't cause concern to none of the people who are viewing this. Now, people are going to say, well, the caveat was that they said because it involved murder. If that's the case, all the judges didn't even agree to that. One judge sat out on it and was like, which means they just kicked the can down the road, bruh. For real. And I'm going to be honest with you. What happens if the Superior Court don't hear this? They say it's not really worth our time and we'll get to it when we get to it. What y'all going to say then? What y'all going to say then? What will be said then? And I'm hoping that the defense is right. For real talk. I'm hoping that the defense is right because the DA's office is dirty as hell, and it seemed like the judge is just, I didn't see that happen. But I would be a lie if I didn't say there were improprieties on the defense side as well. Let's go to Brian Steele, and I'm rocking with Brian Steele. For real I am, because bruh, he going to bat. His price is going up. But Brian Steele had Bean sit up there and say on recording that a cop met with him and basically said that he had the proof and all that. And the proof was that Bean sat up there and said this to Steele 10 years after the fact, but got on the stand and said, I don't recall for 10 years, even though it wasn't written anywhere that Bean met with any freaking lawyer, with any cop at all while he was in the hospital. I was with Brian Steele on saying, bro, I find that difficult to believe that a dude got shot and he didn't talk to the police officers. I find that real difficult to believe. So I was with Steele, but at the same time, still didn't have actual proof that the police actually talked to him, but the recording that he said. And then Bean basically called Steele dirty. See, some of y'all new here. One of the witnesses that Brian Steele and his private investigator went and talked to accused Brian Steele of being dirty. You're not going to go with that part right there, but I'm not calling Steele dirty. I'm just pointing it out. Do I hope that Brian Steele and his compadres are right? Hell yeah, I do. Do I hope this brings more notice to the courts and all that stuff? Hell yeah. That more people fight? Hell yeah. But bruh, I just got a feeling we gonna be here for a couple of more. We gonna be here until next year. I just got that feeling, bro. Y'all can call it whatever y'all want. And we said he Nash was selling and all that stuff. I just got a feeling that what they're trying is not gonna work, but it has to be done. Regardless of my feelings, and I believe that the judge probably right more than he's not, that don't matter. Nothing that I say will affect this damn thing anyways, unless I said I don't know. I would have to say something outrageous. But I just got this weird feeling it's not going to go anywhere, bro. I done seen too many L's. But I hope I'm wrong. I'll actively admit, I hope I'm wrong. Do I have a little bit of a bias towards YSL and Young Thug and all them? I can admit yes. So I fight that bias all the time. I can admit I have a slight bias towards them. Majority of my videos are pro YSL. So when I say anything that's different, understand I was fighting myself to even put it out there. Some of y'all may get pissed off behind that. I can't tell you how to feel. All I can tell you is where I'm coming from. But either way that go, man, it's going to be interesting to see. I don't know, bro. I just have a hard time believing that that's going to work. But we'll see, man. Glanville is the big dog. He's the chief. I don't think y'all understand that part. Being the chief gives you so much power. And that's what Weinstein was trying to tell y'all. But we'll see, man. Secondhand information and y'all doing all this, throw y'all weight behind it. Y'all got to see, because if it works, if it don't, the judge can't be biased. The judge got to go, oh, all right. Which is a win anyways, because, bruh, the judge was allowing the damn defense essentially everything they was asking for. I'm listening. We'll do the video tomorrow, bruh. Brian Steele, even if they lose this motion of recusal and all this stuff, he's already won. And I'll explain how in the next video tomorrow.